Hello, everyone. Welcome to another webinar from Fieldfisher's Silicon Valley Technology and Data team. Thanks for joining today. We're going to be looking at some of the new online safety laws which have been springing up across Europe, and we'll be strategizing about how practically you can go about building a coherent compliance plan. So we've been seeing an increasing burden placed upon online businesses to protect vulnerable groups of people, above all children, from various online harms. So we're going to be taking a deep dive into some of the rules and requirements today, and more importantly, how you start to think about tackling what are quite a large set of overlapping requirements. Now, you may have been expecting to hear my colleague James Russell today, but unfortunately James is unable to attend, so I have stepped in. My name is Natalie Farmer and I'm a partner in the Silicon Valley team. Whereas I'm currently sat in London, I'm joined today by my fantastic colleagues Pardeep Denoya and Hannah Algazar, who are joining us from sunny Silicon Valley. So let's start by taking a quick look at our agenda today. First off, we're going to set the scene a little bit and answer the question, why are we focusing on online safety now? The internet's been around for quite some time. Why are we looking at this today? We're not going to attempt to cover off the nitty-gritty of every piece of technology regulation coming out of Europe, as there simply isn't time to do that. But we will be looking at some key themes, and if you need a more detailed primer on any of the regulations that we'll be mentioning today, we do have dedicated videos on our YouTube channel that cover key aspects of the UK Online Safety Act, the Age Appropriate Design Code, as well as various other EU digital regulations coming up in 2024. So if you do need more information, you can visit our YouTube channel for more. Today, we're going to be pulling together some of the threads which run across emerging laws and which touch upon key online safety themes, including content moderation, age assurance, and the regulation of dark patterns. And our aim is to highlight the trends and arm you with some practical takeaways that you can apply in developing your online safety compliance strategy. So let me pass over to Hannah now, who's going to answer that first question of why are we talking about this?
Natalie. So first, we are focusing on this because of the potential heavy lift here. So the UK Online Safety Act alone includes almost 300 pages of new obligations, not to mention the several thousand pages of consultation guidance and materials which accompany it. And that's just one piece of legislation. So identifying commonalities across various new regimes should be a priority, which is of course why we're going to try and highlight some of those key areas today. Next, risks and enforcement. The risks related to enforcement here are potentially very high. We are all aware of the 4% of global turnover maximum filing threshold under the GDPR, but now we're looking at 7% under the EU Digital Services Act and up to 10% under the UK Online Safety Act. Additionally, some of the relevant regimes create personal liability for directors. Under the UK OSA in particular, a senior manager can face personal liability where their company fails to provide accurate information, for example, with respect to its content moderation procedures in response to an information notice, or where they allow certain of the other offences under the Act to be committed. We're therefore expecting this to be an area of concern for senior management. And finally, why are we talking about this now? Well, there are a number of recent developments which make this an opportune time to be thinking about this. Firstly, the EU Digital Services Act came into force in February, so we expect those who didn't quite manage to get up to speed by day one will now be a significant way through their compliance projects and at a good point to be looking ahead to what future obligations they'll need to account for or bolt on. Second, we've now had both the initial consultation documents from the UK regulator, Ofcom, with respect to illegal harms, as well as protecting children, which means there's considerable corpus of materials on the most significant obligations under the UK OSA to start building on. And finally, that means we can now start looking towards the Q4 deadline the UK regulator set to begin compliance with obligations like risk assessments with a view to building out the necessary updates to processes and systems in good time. So what kind of updates do we need to be making? Well, I'll hand you back over to Natalie, who will talk to us a little about the different requirements for content moderation under the various pieces of legislation.
Thanks, Hannah. So we're going to start by asking, what do we mean by content moderation? And here we're really talking about the systems and processes that ensure you have the ability to both identify illegal content or inappropriate content, but also take it down or restrict access to it as necessary. And you'll see on the screen there some of the pop-up messages that you might encounter, which are indicative of some level of content moderation going on behind the scenes on some of the bigger platforms. Now, these systems often sit at the intersection between a variety of different and overlapping regimes. And here on the slide, you can see that we've identified in particular intellectual property laws, data protection laws, the online safety laws that are the focus of today's session, as well as certain sector-specific regimes like film ratings or app store requirements or perhaps loot box regulations. So broadly speaking, these are the main pieces of legislation that we're really concerned about in this space. And starting with IP law and the data protection laws developed by various age-appropriate design codes, we've now got to think about obligations under the EU DSA and the UK Online Safety Act, or the OSA. So there's quite a lot of different things to think about when we talk about content moderation. At a high level, these on the slide now, you can see who these regimes apply to. Immediately, you'll see that there's often an overlap. So you've got online content sharing services, which are likely to also be user-to-user services and potentially also hosting platforms. So there we're covering off at least 3 of the different regimes: intellectual property, EU digital safety, and the UK Online Safety Act. And potentially then you've got to think about, if you're engaging with children, whether the children's code is likely to apply on top. So what are some of the requirements under these regimes? Now, we will circulate the slides after, so you don't need to study this chart in any great detail. But just to give you a sense of where some of these requirements come from and the types of requirement that we're talking about when we're looking at content moderation, this slide tries to break down some of those key requirements under each regime and also how they compare to each other. So let's start with notice and takedown. It's probably the piece that most of us are already fairly familiar with under IP legislation. So this is the Digital Millennium Copyright Act for those in the US, or the Digital Copyright Act for those in the EU, which requires companies to create notice and takedown systems that allow rights holders to submit a request for content to be taken down where they identify a copyright material on the service that isn't licensed. The EU Digital Services Act then expands upon this by requiring that anyone, so not just right holders, i.e. not just those who hold the copyright, for example, or other intellectual property rights, be able to submit a takedown notice where they identify any illegal content, which includes copyright content, but it goes much broader than that to include any content which is illegal, such as under terrorism laws, anti-terrorism laws, or for example, under child sexual abuse material laws. And by contrast, we then have the UK Online Safety Act, which explicitly carves out IP from the definition of illegal content, be regulated elsewhere, but does include the so-called harmful content, which includes priority content that is harmful to children. For example, pornographic content, or content that could encourage eating disorders or self-harm, among other things. And then similarly, with respect to content filtering, we're seeing a significant expansion with respect to the platform obligations. So whereas traditionally intellectual property laws have recognised a safe harbour for platforms hosting the content of a user, increasingly European laws are requiring much more proactive intervention by those platforms. So in the IP realm, this has led to the controversial best efforts obligation for online content sharing service providers like YouTube, for example, to go seek license agreements from copyright holders or otherwise impose high industry standards to prevent the availability of specific works, leading to the adoption of content monitoring systems like Content ID. And similarly, online safety laws are now becoming more demanding with respect to proactive monitoring, including under the OSA, where there's the imposition of active duties to prevent children from encountering priority content, which includes some of those obvious negative matters like graphic violence, or more subtle issues like discrimination or even bullying. And while the DSA doesn't go quite as far as making duties like this mandatory, it still imposes a voluntary standard of acting in good faith and acting in a diligent manner. Similarly, the UK Children's Code requires that contextual tagging and elements of human moderation are required to prevent children being exposed to inappropriate content, but where the service chooses to engage in profiling activities. Finally, we've seen a tightening of the expectations with respect to risk assessments and transparency, whereas intellectual property laws did not require any specific disclosures to be made in service terms and conditions. Increasingly, EU online safety laws require specific content to be included about the moderation procedures, about the user's rights to complain, and also there are requirements around the format in which some of this information is presented, including that the information is presented in clear and age-appropriate language. Similarly, whereas traditionally one would expect to do some sort of risk assessment as a matter of good practice, a children's data processing impact assessment, an illegal content risk assessment, and a children's risk assessment may be obligatory under legislation like the Online Safety Act. So quite a lot of requirements to unpack there, and I think we've really just touched the surface of those. So how can you practically start untangling some of these issues and making some sort of coherent plan for yourself and your business? Well, we're going to suggest sort of a 3-step approach throughout this webinar, focused on scoping, assessing, and adapting your current policies and practices. So let's start with scope. Really, we're just referring to a process by which you determine which regimes you need to comply with, what it means for you as a business, and what different obligations are on your to-do list. Next, assessment. There are now various assessments that it will be compulsory potentially for you to undertake if you're regulated by the various different legislation. But even where it isn't an obligatory matter, you might want to use those sorts of assessments to understand the scale of potential risks you're exposed to and what proportionate level of compliance for you should look like. And finally, adapt. So wherever possible, we would recommend trying to build on existing processes, anything you already have. So for content moderation, for example, this likely means starting with an existing IP takedown procedure, as well as your community guidelines and terms, and building upon them to include any obligations you have under the various new pieces of online safety legislation. So that's content moderation at a very high level, and there's a lot going on under the various different online safety laws. We're going to move on now to have a look at age assurance, which is the next topic on our online safety agenda. And for that, I'll hand over to Pardeep.
Thanks, Ashley. So when we mention age assurance, what do we mean by that? You'll all likely be familiar with the more casual style of age assurance on the right-hand side of the slide, where there's a self-declaration of age, or sometimes containing a birth date that you need to scroll over and input. Age assurance is a mechanism for determining the age of your users and helps to gain access to certain kinds of online content. However, in recent years, we've seen significant developments in the technologies available with age verification tools, which involve comparing a particular individual against a trusted database of information, for example, photo ID matching. This is increasingly becoming challenged by age estimation technologies, which instead analyze a user's age biometric markers, for example, within a photograph, in order to arrive at an age estimate within a certain age bracket, for example, 30 to 35. These have developed in parallel with greater demands from legislators and regulators for organizations to restrict users from accessing certain kinds of content online and provide services to age-appropriate users only. So let's have a look at the obligations. The initial point of reference will be the Children's Online Privacy Protection Rule, also known as COPPA, which governs the processing of children's data in the US. COPPA imposes only very minimal obligations of businesses with respect to age assurance. COPPA covers online services only where such operators have actual knowledge that a child under the age 13 is the person providing personal information, as well as those that are directed to children. It does not require operators to ask the age of visitors at all. Services that screen its users for age in a neutral way, such as by the use of self-declaration, can rely on the age information its users enter, even if that age information is not accurate. Only if the business determines that a particular user is a child under the age of 13 will COPPA's obligations, such as those of notice and parental consent, be triggered. Nevertheless, businesses must take into account competent and reliable evidence regarding user composition and evidence regarding the intended users of the website or service in evaluating whether they are actually directed to children. The UK's code made this even more explicit. Although this also takes a risk-based approach to recognizing the age of individual users, it specifies that a business must either establish age with a level of certainty that is appropriate to the risks to the rights and freedoms of children that arise from the processing, or apply the standards from the code, the UK Children's Code, to all your users instead. This code is not prescriptive about exactly which method is used. It acknowledges that self-declaration, for example, may be suitable for low-risk processing. However, this takes into account a range of products currently available in the marketplace and the risks relevant to the particular processing. The Online Safety Act, the OSA, then takes this step even one step further, requiring compulsory documented children's access assessments for all user-to-user and search services which fall to be regulated. The latest draft guidance from Ofcom gives us some insight into the procedure expected by analysing whether it is possible for children to normally access the service and then whether a significant number of children are users of the service. We are seeing an expansion of these obligations on online businesses. Under COPPA, the requirements for age screening were fairly limited. By this, we mean that age information is requested in a neutral manner, making the entry point allows users to enter their age accurately, does not default to age 13 or over, and avoids encouraging children to falsify age information. By contrast, the children's codes, so the UK and the California code, are much more prescriptive, requiring the highest possible level of certainty on users' age in the context of high-risk processing. And the UK Online Safety Act goes even further by requiring highly effective age checks for a wide range of services, with technical criteria on accuracy, robustness, reliability, and fairness under the latest Ofcom guidance. The result of these different types of laws is a broad range of online services which will need to be updated, and you will need to improve your existing age assurance programs. Recent cases suggest that regulators are increasingly seeing effective age assurance as a priority as well. However, it's somewhat uncertain over precisely what level of age gating will be considered adequate. For example, in 2022, there were a lot of optimism about some of the age assurance technologies like Yoti, which might be considered the magic bullet. So Yoti is a platform that works by providing an accurate age bracket estimation while simultaneously providing a smooth user experience and minimizing processing of sensitive biometric or identity data, which might turn out to be that of children. Yoti also participated in the UK's ICO sandbox program, and the ICO recognized that the tool did not process special category data and did not uniquely identify individuals, presented with the possibility of the technology's wider adoption across the board. However, only earlier this year, the US Federal Trade Commission, the FTC, when presented with the same tool from Yoti in the context of COPPA, rejected the tool's application for recognition on the basis of concerns about the tool's data collection and storage processing and some issues with negative bias. Similarly, we saw Ofcom, which is a UK regulator under the Online Safety Act, earlier this month, open an investigation into OnlyFans for allegedly having failures in effectively verifying the age of its users. Perhaps even more significantly, at the end of last year, we saw a federal judge block the coming into force of the California Age-Appropriate Design Code, altogether on the basis that it represented a potential infringement of the right to free speech by limiting the ability of children to access a lot of online communities on the internet. but also because the facial recognition and biometric analysis involved in age estimation technologies could inadvertently lead to an increase in the collection of personal data by large tech companies, which kind of directly contradicts the conclusion that the UK ICO had made earlier. This preliminary injunction blocks the California Children's Code from going into effect until this case is resolved. As a result, the California Children's Code looks as though it will not be coming into effect as planned on July 1st, but do make sure to watch this space. So where does this uncertainty leave businesses? What can you do about age assurance now? So returning to our three-step plan, which Natalie mentioned earlier, the same key principles apply of scope, assess, and adapt. Firstly, for scope, as with content moderation, you need to understand which legal regimes you fall under, and therefore how prescriptive or proportionate your approach to age assurance can be. This will be critical. Secondly, assess. It will be essential to assess, document, and evidence your consideration of the age demographics accessing your online services. In some cases, that will involve compulsory children's access assessments and DPIAs. It is important to evaluate the risks you are exposed to and the scale of protections you will need to put in place by doing some degree of analysis. Thirdly, adapt. Adapting existing procedures may be more difficult, as it is clear that regulators are raising the bar in requiring accurate, robust, reliable, and fair mechanisms for age assurance. That said, for lower-risk services which have low amount of age-restricted content, it may be that existing methods such as self-declaration remain appropriate. A key priority is to keep up to date with guidance like the Ofcom consultations and the regulatory decisions like the California Children's Code injunction to see where regulators and market practice land on this debate. I will now pass you over to Hannah to go over a bit about dark patterns.
Thanks, Pradeep. So what do we mean when we say dark patterns? So if you look to the screen, we've shown some examples of things that regulators are looking at. However, developing a universally accepted definition of dark patterns is a challenge, owing in part to the wide variety of practices that can fall under this umbrella and the differing views on whether certain practices should count as a dark pattern or not. In the broadest terms, though, dark patterns are design practices that aim to prevent users from making autonomous and informed choices or decisions, and that may result in some kind of harm or detriment. This is less about the content, for example, advertising statements, but primarily about the structure, design, or functionalities of online interfaces, i.e., primarily websites or apps. For example, by presenting choices in an intentionally lopsided way, giving certain choices more prominence than others, visually, auditorily, or other components. There are also different definitions under law, making it even more complicated. For example, COPPA does not define the term at all. The FTC staff report at the end of 2022 is generally cited as the best insight into the FTC's interpretation of dark patterns, which says they are design practices that trick or manipulate users into making choices they would not otherwise have made and that may cause harm. By contrast, the Digital Services Act to some extent codified previous European guidance by defining dark patterns as practices that materially distort or impair, either purposefully or in effect, the ability of recipients of the service to make autonomous and informed choices or decisions. This contrasts again with the ICO's Children's Code of description of nudge techniques, which are design features which lead or encourage users to follow the designer's preferred paths in the user's decision-making. Although the details here vary, there is clearly a consistent common core of practices which the regulators are seeking to suppress. This is also an area where, for once, the UK Online Safety Act does not seem to represent the high watermark we expect. Rather than making detailed provisions for dark patterns like the DSA does, the OSA instead includes broad duties, for example, to mitigate and manage risks of harm to children, taking into account design of functionalities, algorithms, and other features, amongst other factors, but not directly mentioning dark patterns. However, it's also worth noting that this is also an area where specific dedicated consumer laws also intersect with online safety as well. For example, the UK government has recently made further targeted provision for dark patterns in the Digital Markets Competition and Consumer Act, which received royal assent only a few days ago. This contains specific provisions on so-called subscription traps, whereby consumers are provided limited information on few or low-cost trials and suckered into committing to a longer, much costlier long-term subscription, as well as other niche issues like fake reviews. Depending on your definition, one could also potentially analyze the controls on recommender systems under the DSA, the Digital Services Act, its prohibition on digital advertising to under 18s, and the privacy by design requirements of the privacy laws to set privacy settings to children to the maximum by default as dark patterns. Although we don't have time to go into detail on these obligations, the central theme is much the same in all these cases. Companies are being increasingly prohibited from engaging in these kinds of sharp practices when it comes to dealing with vulnerable groups like children. Broadly speaking, this can therefore be characterized as an area we see a significant degree of overlap in the objectives being pursued by different regulators, but where much of the detail falls to be decided by the particular context in which the dark pattern are being expressed. As we saw with age assurance, this is also an area where we have seen significant enforcement activity in recent years. To highlight just a few examples here, Epic has found itself in hot water on both sides of the Atlantic for its use of dark patterns, with respect to its monetization methods within its flagship game Fortnite. At the end of 2022, we saw an enormous $520 million settlement resulting from a combination of copper violations and dark patterns. Just earlier this month, we saw the same company fined €1.125 million for unfair commercial practices aimed at children by a regulator in the Netherlands. As regulatory scrutiny increases, companies will therefore need to be more proactive in reviewing and adapting their user environments to the latest best practice. So what does our scope, assess, adapt approach suggest here? Well, with respect to scope, we'd firstly suggest here the particular regime you fall under may be less important than identifying the sector-specific guidance which applies to your industry. At the legislative level, the general continuity in approach means that what will likely be more helpful is identifying what particular practices are being met with regulator scorn and which are considered conventional market practice. Here again, assessing your existing practice is therefore going to be central to identifying gaps, mapping the scale of necessary changes to user interflows, and also assessing sign-up flows, etc. The cross-pollination between the regimes here also makes this a prime target for adapting existing procedures to tick several boxes at once. For example, updating your consent collection to provide truly neutral yes or no choices might all at once satisfy requirements under COPA, the Children's Codes, and the EU Digital Services Act. Which I think then brings us almost to the end of today's session. So I'll hand you back to Pardeep to wrap us up with some key takeaways.
Thanks, Anna. So the big three takeaways from today's webinar are, first of all, Europe's new online safety laws add significant new complexity to the legal landscape. There's a lot of new material to cover here, and the potential for significant fines or personal director's liability should make your organization take notice of the lift that will be required. Secondly, the time to start acting is now, with the DSA now in force and your compliance projects hopefully starting to reach maturity. Now is the time to be looking ahead to some of the next implementation deadlines, which start in Q4 of this year. Finally, where possible, try to build on existing documentation and processes. The sheer number of new obligations from various laws and regulatory guidance means you'll be wanting to be looking for efficiencies wherever you can. Thank you all for attending our webinar today. We didn't get a chance to speak about many of the other new obligations coming under the new online safety regime, such as annual reporting, cooperation with regulatory authorities, assigning local representatives, etc. So if you do want to hear more about these topics, make sure to check out our blogs, podcasts, and other videos on our Fieldfisher Silicon Valley YouTube channel. Also, make sure to sign up to our next webinar on June 13, where we'll be looking at AI in recruitment and be considering some of the key legal issues, latest guidance, and tips for staying compliant. If you have any questions about today's webinar, please do not hesitate to reach out to us. We're always happy to hear from you, so please do drop us a connection request on LinkedIn using the QR codes on the screen right now, and get in touch using the contact details on the screen. We look forward to hearing from you. Thanks again, and we'll see you next time.